Okay, it is Monday, April 8th, 2019, and it is 8:30 p.m. Central Standard Time. And welcome to week 2 of constitutional law. And so there are a couple of things I'm going to talk about. I'm not going to go over the things I went over last week in the very detailed open house, but I do encourage you guys to make sure that you pay close attention to the things that I provided in the open house. So I'm going to go right ahead, and I'm going to start sharing my screen so we can talk about the assignments for this week. Okay, well, first of all, oops, let me make this smaller. I don't know why it got bigger. Oh, I know why, because I clicked. Maybe I don't want this as big. Okay, let me do this. This is supposed to move. Why this is so big. There we go. Let's make it smaller. There we go. Okay, so I just want to, there, boy, this thing. Okay, so let's move that up. Okay, so now I'm not going to go over this page here. I covered this in details last week. I'm not going to repeat it, this material here, but I am going to look at the written assignments for this week. Briefing a case, and it includes facts from the case, includes procedures, includes issues from the case as well. I am also going to send you, let me make a note, briefing the case. I have something that I will send you after this that will help you with that. I will send that to you right after we get through here. So anyway, you're going to make sure you satisfy all these requirements. Make sure you do the APA citations and references. And so I'm going to provide you with information about how to brief a case that will help you to satisfy this requirement. So you will look for that email along with the time. Well, I'll send that to you before I send you the archive, because it's going to take me a little while to convert it. And then this week, this is the first week, you have the Fourth Amendment Project topic selection. So what you're going to do is you're going to select a topic related to the Fourth Amendment. Explain why that topic was chosen, and meet the page requirements, including correct spelling, grammar, punctuation, and of course APA. I will go elaborate more on the page requirements in just a minute in the module. So that's week 2. Then I want to remind you the lectures take place from 8:30 now to 9:30 or less, but at least to 9:30. If we go, we won't go much beyond that. So that'll be for weeks 2, 3, 4, and 5. And then when we get to week 5, I'll remind you about the special on the home page. Somebody had already asked me, where do I find the archives? Right under recording, and you can copy and paste the link. I also emailed it to you as well. Okay, so let's move right along, and let's get to the other side here. Here we go. I'm done with these announcements up here, but you can always look at them. So I'm going to focus on this week. This week we're going to deal with equal protection under the law. And to prepare for that, you would read Chapter 4 and Appendix E of your textbook and complete the activities Equal Protection under the Law and Briefing a Case, which we're going to talk more in detail about that during this lecture. And then this week, you will discover that you have one discussion assignment. Last week, remember, you had 2. And is it really equal? Oh, no, there's 2. I stand corrected. There are 2 this week as well. One is it really equal? And then the second one is on prisoner equality. And I'm going to go over the information regarding that. And of course, you know, my policy initial posts are due tomorrow night by 11:59 p.m. Central Standard Time, and the reply post is due Saturday by 11:59 p.m. Central Standard Time. Some of you took advantage of the fact that you posted your reply post on Sunday, which if you did, you got points for that, but I deducted a point for it being late. But you had to at least submitted your initial post on time. Not even on time, I should say, by Saturday at the latest. If you submitted them both Sunday, doesn't matter. You're not going to get points for it because, as I said before, the discussion forum is over. But I'm giving you a little extension, so to speak, of 1 day for the reply post only, not the initial and reply post. Finally, you're going to complete the written assignment, briefing a case, and the Fourth Amendment project, which we just talked about, and we're going to go into more details. You know about my motto. You know what that is all about now. So let's go and take a look at the course calendar. Okay, and then you see that there. This is where we are today. Your reading assignment, again, if you click on that, it opens up and tells you something I already told you. Then your live lecture, open it up, and it tells you something that you already know, like the link, because you're here, and then what we're going to cover as a result of that. Your initial post for both are due tomorrow night, as I said earlier. Your reply posts are due both, okay? So when we get to week 3, that's when we have 1 week. That's when we have just one discussion post. But you can see that by looking at your calendar. Then, of course, your written assignment is due the 14th, which is Sunday coming up, as well as your Fourth Amendment project, the first part. And then you'll see 3 check marks. These check marks tell you that these are the due dates. And then also one of them, I think it's the bottom one. Yeah, it's for the live lecture. And your keyword that I will give you at the end is how you gain your points. And then we'll start for week 3 on Monday. All right, so that's the calendar. Again, the whole calendar is available to you anytime you want to go and look at it. I do encourage you to keep up. I did send you the Chapter 4 information about the module, the PowerPoints, so that you will have them, okay? So, all right. I do want to say that many of you did pretty well with the discussion forum on judicial review. Many of you, I noticed, took the position that many people take, that there should not be a lifetime appointment for the justices, and also some issues with the president selecting those individuals for a lifetime. But when the Founding Fathers did this, as I pointed out to several discussion posts, they intended for there to be a check and balance, because what would happen is that the president, the executive branch, would submit a selection. And we all know that when the president makes a selection, it's going to be someone they feel not just will follow the Constitution, but unfortunately it's become more political, where the president selects people who think like them. And, you know, so we have had 2 selections already under the current president, Brent Kavanaugh, and I forget the first name. But anyway, and Ruth Bader Ginsburg, if something happens to her, there's going to be another selection. So it impacts quite a bit because the Supreme Court is the highest court in the land, as you know, and their decision is final in terms of interpreting the statutes. And their role, as under the famous case of Marbury versus Madison, 1789 case, I believe it is, stated way back in that point that it is the court that interprets the law. No, 1803. It was 1803 case. And I cited the cases Marbury versus Madison. If you want to look at it, 5 U.S., which is United States, 137. And you can also Google it and find the information. But anyway, so judicial review was established with that case. And since that time, it's been quite clear that statutes and interpretation of statutes that deal with constitutional issues end up before the United States Supreme Court if they decide to accept it. They don't accept all the cases, but cases that have major impact, they will accept them and they review them. But again, the issue is whether or not there should be lifetime appointment. Some of you said that it should be for a few years terms and then, like the president, run again. Well, it's not an elected position, it's a selected. And remember, the check and balance kicks in because it's the Senate by I forget what the vote, I think it's 2/3 vote. But anyway, it has to be approved by the Senate. So it's a form of a check and balance. Now, it does become a problem when the Senate is controlled by one party and the presidency is controlled by the same party. There could be some, I don't want to use the term collusion, but there could be some issues because, be aware, that is why it's so important to vote, people, because your voting determines your legislators as well as your executive branch president. The president appoints who he wants to for his cabinet, and then he can make selections to the United States Supreme Court. And again, it's the U.S. Senate that has to confirm those individuals. So it's up in the air. I personally believe that the Constitution was right about how they did U.S. Supreme Court justices because they take on a heavy, heavy burden. And remember, when the Supreme Court says something by a majority, and you know, it could be as close as 5-4, which many decisions have, and you know, it could be 6-3. But when you closer you get to a large number majority and small minority, then you find that it lasts longer, and it's harder to change things. If it's 5-4, just one justice or two justices can change that. That's why this whole issue about swing votes and all of that are involved as far as the Supreme Court. So it's so those of us who are political scientists, which I got a degree in that, and also lawyers who have studied the Constitution and continue to understand it, it operates pretty well. Nobody's going to be happy all the time, but I don't think that the justices, if they were elected, would be able to, we don't want them to have repercussions. Even the president that appoints them has no say-so about their decisions. But just remember what I said is that the president takes a risk when they appoint. Just like, for example, I've already discovered that Justice Kavanaugh, who was appointed by the President Trump, has not always gone along with the decisions that people thought he was going to go in because there's conservatives, there's liberals, there's swing, middle of the road, and all of that stuff, moderates. So it depends. It depends. But remember, the key thing, people, is that the decisions that the Supreme Court issue they are bound by what the U.S. Constitution. So it's a question of them interpreting the law within the context of the United States Constitution. So I thought I would share that. And then the other one that was interesting in the discussion forum was what is your most important amendment that relates to criminal law? Now, I said at the beginning, and I'll say it again, that the Fourth, the Fifth, and the Sixth Amendment are like the core when it comes to dealing with criminal law and what the courts deal with. The Fourth Amendment, unreasonable search and seizures, deals with your privacy issues and things like that. You got cases like Mapp versus Ohio. You got the stop and frisk issue, and then with the Fifth Amendment, the infamous and well studied Miranda case, Miranda versus Arizona, which everybody knows because people, even if you don't take a course, you know the Miranda rights kind of, sort of. But I have a special tie to that because I shared this with some students who took me in criminal law, that the United States Supreme Court took techniques that were used by law enforcement in the Miranda case to task. And because they didn't like those techniques that were used, came the infamous Miranda warnings that police are required to give whenever an individual is in custody. And as you know or may know or will learn, that custody means when you're not free to go. You don't even have to hear the words "you're under arrest," but the definition of under arrest is when you're not free to go. So a simple question by a person is, am I free to go? And if they say no, then you're under arrest. And if they ask questions, it is advisable that they give the Miranda warnings. But what I was going to say is that I had a professor by the name of Fred Inbau, F-R-E-D, and then Inbau, I-N-B-A-U. You could Google him and you can see it. That we used to call him Freddie the Cop. And it was he and another guy named John Reed who wrote a book on interrogation and confessions that was used in that case, that was used by police in their techniques, and they utilized that book for their teachings. Well, he personally took the position that he was maligned by the United States Supreme Court, and until the time he died, he would file what we call amicus brief or amicus brief whenever a case came up regarding the Fifth Amendment and Miranda. And he wanted it overturned, which I doubt if it's going to happen, but he passed away some years ago, and it's still in existence, and it's still important to protect the rights of individuals, and police are required to satisfy all of those requirements in detail, following the right procedures, and otherwise a defense attorney, which I spent most of my career doing, could file a motion to suppress statements that are obtained, and those statements could not be used in a court case. And what it did is it weakened the prosecution's case against the defendant. So the point of the matter is so the Fifth Amendment is pretty big, and Miranda has been very controversial. I don't see this court even as much to the right as they are, that them doing away with it. Now, what has happened is that the way that it works is the courts don't overturn it, but they will, except in rare occasions, they will what we call chisel it down by cutting into it a little at a time by decisions that take place and so forth and so on, of cases that come up before the United States Supreme Court that they decide to accept. So that's the importance of the Fifth. And then, of course, the Sixth Amendment is famous because of the infamous case of Gideon versus Wainwright, where an individual represented himself in a criminal case, and he was found guilty, and the case went all the way to the United States Supreme Court, where the Supreme Court came back saying it is a fundamental right that individuals should have, under the Constitution, should have legal counsel. And that legal counsel, adequate legal counsel, should be able to represent them, because Gideon was not a lawyer, and he could do things to hurt himself in terms of representation. So therefore, if you have a case where jeopardy is going to attach, not a fine only, but where you are subjected to any kind of incarceration, no matter how small, whether it's 1 day or not, then you're entitled to attorneys. And then, as you already know from Miranda, if you can't afford an attorney, then and you're indigent, that the courts will appoint an attorney. Generally, it's the public defender, which, by the way, I'm going to make an announcement about that. People oftentimes say they want a real lawyer. Public defenders are as good as private attorneys. The only problem that they really have is that they have a volume and they have to keep their caseload going. Private attorneys, such as myself, we could decide how many cases we want to handle and give our attention to that. But the caseload for PDs or public defenders is pretty voluminous. I have a cousin who currently is a public defender right now. I was invited to work with the public defender's office as a high-level attorney, but I was ready to retire, and I didn't want to do it. One of my classmates was the Cook County public defender at that time, and she solicited some of us to come on board, and then another friend of ours came on, and he tried to reach out to us, and one tried to pull me out of retirement. I said, I'm not doing it. And so anyway, I just wanted to make that statement about public defenders. Back to the Fifth Amendment for a minute. It talks about self-incrimination. You don't have to testify against yourself. So therefore, a defendant does not have to testify in a case. Now, and it should not be held against him. Now, that's the way it is. Just like the presumption of innocence should be the instance. Unfortunately, the application of the way it works in real life is the opposite, is that it's presumed oftentimes that you weren't charged improperly, or that you did it. So that's a violation of that. And then there is a presumption sometimes when a defendant doesn't testify in a trial that they're holding or hiding something. Well, that may even be true, because I have had clients that I didn't put on the stand because they had diarrhea of the mouth. That is, that they would answer questions, and the prosecution and cross-examination would eat them alive, and they would end up tripping them up. And so I would elect not to. The other reason why many defense attorneys elect not to put a defendant on the stand is because that defendant may have a prior, and the prior conviction cannot be brought up if the defendant does not testify. But if the defendant testifies, that can be brought up to challenge the credibility of that defendant who takes the stand. You know, so it will weaken the defense case. And so it's a strategic move that many of us have had to make. So I just wanted to comment about those, but you guys put some very interesting points together. So that was awesome, and I hope you will continue to do so. I do more commentary on discussion posts in this class because it is exciting to me, the issues such as this week, the equal protection under the law, which we're going to talk about in just a minute here. Okay, so now let's take a look at now the assignments again in detail for the week. As soon as I can get my computer to do its thing. Come on, computer. There we go. Thank you. So anyway, so let's talk about your course project. So the Fourth Amendment, you look it up. Now remember, it says you're looking on the internet and in the library. Be very careful about stuff. Do not, I repeat again, use that website that starts with a W and ends with an A. And you all should know what I'm talking about. If you do, you're going to lose points. I'll just say it, it's Wikipedia. Don't use that. Use credible resources. There's a lot of garbage out there, but there's some really, really, really good stuff. But give credit in your papers, citations in the body, and you saw the academic integrity video last week, and so you want to make sure that you don't violate those things. And then you want to run your papers through Grammarly so that you can have adequate critical thinking. And all you guys are now in the Bachelor Completer, and I don't think there's anybody that's not in it. But anyway, the point of the matter is that you are well versed in critical thinking. So I look at your papers very, very, very close for content, detail, and information. Just like some of you wrote that preamble, and it was just too brief. And I'm going to be grading some now. But I made a statement last week that it should be more than a paragraph. The deal is that you got to remember you're in college and you're heading toward a bachelor's. And one paragraph of giving some information is generally not adequate to satisfy the requirements. We want your thoughts and analysis as well. So anyway, so this week, the Fourth Amendment, review cases and secondary sources, and there's a lot of stuff out there. I mean, there's tons of stuff on the Fourth Amendment. I provided you with some additional information other than the PowerPoint, and you can look through that and you can find some very good clues to help you with this assignment. So after you've extensively, you see what it says, extensively reviewed this amendment and the law surrounding it, pick an area within the Fourth that you would like to research further and then do so. It says write a one-page paper. One page is not one paragraph. One page is not two paragraphs. You know when one page is one page. And make sure you can go beyond one page, but make sure that you have citations in the body and references in the end, and that you're not just copying and pasting information. When you cite cases, I expect you to cite the cases and go look for the original citation, just like the one I just gave you a few minutes ago about Marbury versus Madison. Find those citations. Utilize those in your papers. Some of you will use fine law, and some of you will use Justia, which is good, but get the citation of the case and include that. So the citation generally it includes the name, X versus Y, and then it'll say the source that you got it. The U.S. means United States Supreme Court, and then it'll say the number at the beginning is the volume of the book that you find it, the volume of that, and then the last is the page number where the case starts, and that's adequately doing it. And so you're going to have to deal with that with your briefing assignment anyway. So write a one-page paper indicating what area you've chosen and why. Give it some thought. Prove should be corrected for spelling, grammar, and so forth. And so complete it, with a cover page and your citations and references. All right. Now that's the so it's not an onerous. See, let me say this: researching is very important before you put down your assignments. It's not like wham, bam, boom. No, it's not like. And please do not cite your textbook as the major source. Don't do it. Please don't, because the idea is, as we say, read it. It says, look up in your text on the internet and library. Review cases and secondary resources. After you've done extensive, I said extensive research. Just using your textbook, that is not extensive, okay? We want you to get into the habit of being able to operate. Remember, we were talking about information literacy as one of the transferable skills, being able to find information. And then your second written assignment is briefing a case. And for this assignment, you're going to brief Terry versus Ohio, which you will find fits in blank amendment. I'm not going to tell you. You should already know that. We called it the infamous, I already talked about it, Terry stop. And see, here's what I was talking about. Here's the correct citation. See, it's Terry versus Ohio. This is the 392 volume of the United States Supreme Court official publication at page 1, and the year that the decision was handed down was 1968. That's a correct citation. That's the way you should have for your cases. They don't always have to be Supreme Court cases, but to be honest with you, when you're doing constitutional law, there's plenty of United States Supreme Court cases out, especially dealing with this issue. So follow the directions given in the briefing, the case page. And like I said again, I showed you, but I'm also going to give you something in addition to help you as soon as I finish this lecture. My goal is always to provide you with enough resources to help you. That's why somebody said, you gave us the PowerPoints, and now you gave us this other information. This is too much information stuff. I said, no. It helps you to conduct your research. It helps you to put together. So, man, when you have to write a paper, it's not as simple as just going to one place and using the information. Don't do that. So now we got your discussion post. Is it really equal? And our Constitution says that everyone has equal protection under the law. And you should know where the equal protection under the law originates, what part of the Constitution, where it is. And so you're asking questions just because we're entitled to equal protection. Is that really true? Give your analysis. Is it fair? How can the legislature go about making it more equal for everyone? Well, remember what I told you. When the legislature passes a law, we use a term that it must pass constitutional muster. And I didn't say mustard now. We're not talking about something to put on a hot dog. Mustard, which means it must pass the challenge to be consistent with what the United States, what the U.S. Constitution says. Remember, the Constitution of the United States is interpreted by the cases that the Supreme Court decides. That's what I said earlier. Just always keep that in mind. And then make sure your responses are professional and courteous and so forth. We already talked about that. And give me details. Don't just bam, bam, you know. And you know when they're due. I'm going to go over that again. And then the second one is prisoner equality. What we're doing is we're setting you up to get that gray matter going, thinking about equal protection also comes up in prison cases. There's this constitutional thing that you're going to run out called 1981 cases. I gave you a tip. I'm not going to tell you what they are, but you will find out and you'll know what that is all about. But it is a section of legislature that deals with usual equal protection issues and in prisoners, when prisoners are in. Just because you committed a crime and found guilty or pled guilty, you still have the right to be protected by the United States Constitution, and you have rights. And a lot of 1981 cases come about. That is not the year either. So then, do you think inmates should be allowed to file as many petitions as they please? Again, there are certain things. In an earlier class I taught, there's a law in place that takes the cases that are filed through a certain process before they're allowed to reach the courts even in an administrative, and I'm not going to go into it, but you can research it. Many of you already know what I'm talking about. Those of you who took, I think we did it within Introduction to Corrections. I believe that's where we dealt with that issue. And with a limit on petitions for inmates to be more selective in their petitions, why not? Because trust me, I have seen inmates present cases that were what we call frivolous lawsuits and take up a lot of time in the court. So anyway, so your initial response is going to be due, according to the rules here. And then finally, your live lecture, okay? So I've kind of given you quite a bit of information and ammunition to operate with. So now I'm going to shift, and I'm going to go to the lesson section, the lesson content, where I'm going to hone in on certain things, all right? So we're going to talk about equal protection under the law and briefing a case. So what I told you, but once again, I will provide you with a document that will help you that I have in my file that will come in the form of an email. I've already talked about the Fourth Amendment Project, introduction, and selection of the topic. We already discussed that. Briefing a case, and then we discussed these two issues here. So, the Equal Protection Clause of the United States Constitution originates from the 14th Amendment. Clicked on that. Oh, okay, they didn't show it. Okay. Oh, I know why they did that. Okay, you just have to go back. And actually, the reason they did that is they got some stuff in here. I really take the task with them that they put in here, and we'll talk about one of them in a few minutes, that it actually gives it right here. So here's all persons born or naturalized in the United States and subject to jurisdiction are citizens of the United States and of the state wherein they reside. No state, notice it state, remember there was 50 right now, they're vying for 51, which they're trying to push Puerto Rico as the 51st state, shall make or enforce any law which abridges the privileges and immunities of citizens. In other words, no law should be passed that violates the Equal Protection Clause. That's basically what it's saying. Nor shall any state deprive any person of life, liberty, or property without due process of law. Due process of law comes in the form of going through a hearing. So that's why I just talked about earlier, the presumption of innocence, and that the standard in criminal cases is beyond a reasonable doubt. And what defense attorneys do is they don't try to prove that their client didn't do something. Listen to me. In most cases, what they do is, in a jury case, is begin to chip away at the state's case by getting one or more jurors to take their position. And if that happens, you could end up in a hung jury, or if there, and then if there is a hung jury, the judges usually try to have them to see if they can work it out. If not, there's a hung jury, and then that individual is not found guilty. Or if the majority doesn't find, not the majority, I'm sorry, if you're not a unanimous vote of the 12 in a criminal case, or it's a felony, it's 12, but in a misdemeanor, sometimes it's 6. If all of them don't agree, then due process has been met because they've heard all the evidence, they've had a chance to consider it, and then they are the final arbiters of whether or not a person violated the law. So notice it says that deprive any person of life. So that means, talking about, here's where we get to the life issue. where we deal with wrongful, not wrongful convictions, but law enforcement or someone in authority taking the life of an individual and taking it into their hands, such as excessive force that results in the death of an individual. We had a case in Illinois here of a police officer who was successfully prosecuted on for murder of a young man because he fired 16 shots in it, the famous Laquan McDonald case. And in that case, that individual was found guilty, and he is now in prison. People aren't happy with the sentence, but the fact of the matter is that the jury decided that he deprived someone of life unjustifiably, and violation of the 14th Amendment and the statute in the jurisdiction Illinois, that he was guilty of aggravated battery with a aggravated assault with a firearm that resulted in the death, 16 shots, and then second-degree murder. So he was only sentenced on the second-degree murder. That's a whole nother discussion. But anyway, I'm trying to explain to you the words how life is deprived. Liberty, that's easy, by being locked up for even a day. Or property. So in other words, seizing property of an individual without a hearing. And then, of course, you recognize that in dealing with property, there generally is a civil case, such as I'll use the most recent case here, and here in Illinois, Jesse Smollett case, where the prosecution decided not to prosecute and dropped the charges. Well, the city is now bringing civil charges against Jesse Smollett for the amount of money that they feel that he owes them. And so there's going to have to be a hearing. It's not they have to sue him. You have an attorney, and then that will be by a preponderance of the evidence. Now, that also happened in the infamous O.J. Simpson case, where O.J. in 1994 was found, 94-95 was found not guilty of murder, but subsequent to that, the family of Nicole Brown Simpson and Ronald Goldman filed a civil suit, and you know the results of that is that by a preponderance of the evidence, it was determined that he was guilty of depriving those individuals of their life and therefore the ability to live, and so his property was seized and a judgment was entered, and he's having to pay for that as well. So that's kind of how it works. So due process, a hearing provided with the opportunity to cross-examine the witnesses, take a look at the evidence that the other side has, and then let a neutral party, usually it's a judge or a jury, decide whether or not there was a violation of the law. But due process, and if you listen to the words due process, I actually did a lecture one time on due process, and it explained it as well. Nor to deny any person within its jurisdiction of equal protection of laws. What does that mean? Just what it says. All parties should be treated equally. And that's it. However, the question is that really what happens? For example, let's talk about some of the things that happen here. With jury selection. Now, when an individual elects to have a jury trial, each side has a right to pick the jury, and they can challenge a person for cause. For example, if an individual, says I can't be fair and impartial, or that that the victims or something is a family member of mine, or something along those lines, something that indicates, and the person may come out of their mouth and say something that biased, like, yeah, I think they did it because they wouldn't be here otherwise. Boom, that they can go for cause. However, if there is not a way to do it for cause, and those are unlimited, lawyers from either side use what we call preemptory challenges. And usually in jurisdictions, they give you a certain number. Now, you can remove jurors without giving any reason at all. You don't like them, you don't like the way they look, you know, you looked at their application form card that they filled out telling about themselves, their education, their knowledge or beliefs or something like that. You don't have to say it. So you don't have to state the reason. But in the Baston case in 1986, the United States Supreme Court said these words pretty much in ruling the idea that jurors cannot be removed based on their race. Now, remember I said earlier you could use a preemptory challenge without any reason. But if it is apparent that you are removing minorities because you don't want them on the jury, or Caucasians because you don't want them on the jury, or, I mean, we get to sex as well, females and males. So if it says the lawyer believes that the other side is removing a juror based on race, they can file what we call a Batson motion, and then a special hearing is held to determine if that peremptory challenge is being used improperly. So remember, the law wants you to have a jury of your peers, and they want you to be, the jurors to be consist of individuals who are, quote, impartial. Okay, all right. So that's what that's all about. So notice what it says here, and I want to read this because it tells it to the heart. It says the same protection principles as are applied to determine whether there's a discrimination in selecting the veneer, that is the jury, also govern the state's use, or the prosecutors in the state when they say that, use of peremptory challenges to strike individuals from the jury. So although the prosecution ordinarily is entitled to exercise peremptory challenges for any reason, as the defense is as well, as long as that reason is related to view concerning the outcome of the case to be tried. But the Equal Protection Clause, this is where it kicks in, forbids the prosecutor to challenge them based on the account of their race. Now, no prosecutor in their right mind will turn around and says, I don't like blacks, I don't like this type or that type of person on the jury. They won't do that. But that's what they do. It really happens. And so, but the clause is designed to forbid the prosecutor to use these challenges that they have a right to use anyway to discriminate, so that black jurors as a group would be unable to impartially consider the state's case against a black defendant. So you get the point there. And notice again, it gives the name of the case and the full court citation, 476 U.S. 79. Now, and 80 is in there, but the actual is for the beginning is 79 and it's 1986. You know, so notice that this Batson, this is what I was saying to a few minutes ago, is that now it is extended to age, gender, and religion. So same thing now with LGBT and that kind of thing. So it's here's the deal. The equal protection is everybody is entitled to look through the eyes of justice. I hate that term, but anyway, it is saying, because it's controlled by men. If you ever saw the Statue of Justice, it's a blind lady wearing a blindfold, and she's got scales in her hands. And the key thing is that we want to balance the scales so it's fair to everybody, both the prosecution and the defense, which means it's fair to the people of the state as well as the individual who's being tried. So that's kind of where we're at in terms of that. So I think that you get the understanding. I mean, it is a concept that is equal to protection really equal? Well, that's something you're going to determine from your research and so forth. So I can tell you that there is a lot of discrimination in criminal justice. There is police misconduct. There are individuals who are wrongfully accused. You're seeing a whole bash of cases now where individuals are being released after it's discovered that they've been incarcerated for years and years and years and years in real wrongful prosecution cases, and that with the advent of DNA, which didn't exist when I first started, it has helped many individuals who have been in jail for years and years and years. And you're seeing almost all the time now big money judgments that these people are able to get for having been incarcerated. And also in our jurisdiction, we had the infamous late police chief, not police chief, he was a commander of a police district in Chicago. We called it the Burnside District, and it was 6th District, which was a court. It was not a court, but it was a police station. It was located in Chicago originally at the corner of 91st and Cottage Grove. We called it Burnside. And what we discovered there is that this commander in the 70s and the 80s, and even in, I think, the 90s, and I had a few people who were victims where confessions were forced out of them, beaten, believe it or not. And it was people electoral attachments to privates of their body, all kinds of stuff. As if you know anything about the Geneva Convention, there are certain things that the United States cannot do in wartime to prisoners. Well, there were things that violated the Geneva Convention that were happening in these. And so there were confessions that were not given freely and voluntarily. And so there's been research done, and you can take a look at this, the Bureau of Statistics, and it tells you numerically that in 2010, which is about almost 10 years from ago, whites represented 44% of all jail inmates, blacks 38, and Hispanics 16. And these percentages remain nearly stable until mid-year. I don't know about that. I don't know what they're looking at. I know when I go to jails and prisons that I see, I don't see 44% of the inmates being Caucasian. I don't see it. I just don't see it. And you know what I'm talking about. And I don't know where they're getting this information from. And so it's, you know, it's like the census reports. You know, if it's not done properly, the numbers, you know, your eyes can see and your experiences, you know. And so I don't know. I take issue with these statistics, and I have down through the years. When I was in college, we did research in our political science about who is in jail and who is not in jail. And it was heavily weighted on blacks and Hispanics. So, you know, I don't, like I said again, I don't know who's given this information. And so it says in a survey of 40 urban counties in 1998, 62% of the juvenile felony defendants were black, 20% black, white and 16% Hispanic, and almost 2% were another race. Now, that to me seems more realistic, except that even looking at that, I still say 62%. That's still, I'm just going to go out on a limb, and I'm going to say that probably it's 80% were black, and then maybe about 10% were Hispanic, and then the other 10% maybe Caucasian or something like that. But anyway, I'm just telling you, I worked in the system, and many of you who are in corrections can vouch for what I'm saying. So I don't know where they get this stuff here. You know, your statistics are only as good as the individuals or whomever is providing the information, the statisticians. According to the Bureau of Justice Studies, in surveys done in local police departments across the country, it was found that only 1 in 4 officers were member of racial or ethnic minority in 2007. That is accurate. And now there's more parity happening across the country, but I still know a lot of jurisdictions. I'm not talking about like smaller departments, because it's definitely there, but I'm talking about major cities like Chicago, New York, Detroit, LA. Now there's movements and changes. Particularly, I can speak for Chicago. And what they had to do in Chicago was there were lawsuits, and I actually worked with a group when I was in law school. I mean, in college, in my research in political science about the height restrictions, so that minorities such as Mexican Americans were shorter and didn't fit the standard for being able to be selected in the police department. So those kind of things have changed. There are more females now than there were because of the many lawsuits. But so anyway, there's some changes since 2007 in ethnic minorities, but we still got some ways to go. Because here's the deal, people, and this is the realities of it. I'm not being racist when I say this. I'm saying that it is not just the race of the officer that handles the case in the community, but it's how the individuals who are officers perform professionally. And both Caucasian as well as African American and Hispanic officers are guilty of police misconduct. That's my whole point. But unfortunately, what happens is there are some people in the community that paint it with a broad brush, and you get what I'm saying. So results. So here's the deal: is that, and I tell my students from 3 tiers, and those of you who in this class have had me in several classes: ethical, professional, and educated individuals in criminal justice will help to fix these things. And we need to create better community relations between law enforcement, between corrections, and everybody, and the communities, period. So it says in data collected from federal law enforcement agencies, only 1/3 of federal officers were members of a racial or ethnic minority in 2004. I remember, and I've shared this before, that when I was in high school, my plan was to go to the FBI and I put in an application and go to Washington, go to school at night and work in the FBI and work my way up to becoming an agent. There were accountants. They were pretty much taking accountants and lawyers at that time. They were taking scientists too, but the biggest portion were the first 2. And so regarding my deal, I was going to go to law school, go to college, and get my law degree later, and then go work for the FBI. But I was turned down summarily. We discovered that a letter that many of us received years and years later, that the present not the present, but the past head of the FBI, J. Edgar Hoover, which the FBI building is named after, was a staunch racist and sexist. He was dismissing or not allowing the FBI to deal with, provide any kind of minority or female representation. So he was sexist as well as racist, and that is a reality. And so that has gone slowly. I know a lot of FBI agents. I know people who are from both races who are FBI agents. And now you're beginning to see also more minority as well as female officers. And this goes for not just the FBI, but in the Secret Service. Now we have Homeland Security. We didn't exist. Now we have ICE and Secret Service. Let's see, and it goes on and on and on. Okay, so so it says here that in 2004, that's the way it was. This includes 17.7% who were Hispanic, 11.4% were Black or African American. In 2002, racial or ethnic minority officers comprised 32.4% of federal officers, not quite 1/3 even. So according to the Department of Justice, the racial disparity, and we're about to end here, for judges. Now let's talk about that. Ooh, man, don't get me started on that. Across the nation is extreme. So in 2004 in Wisconsin, there were 240 circuit court judges, 229 of which were white, and only 6 were African American and 3 were Hispanic or Latino. We still kind of have that same issue today, except that's changing. I would say in some counties. I live in Will County. We don't have that many minority judges. We don't have that many female judges. As somebody says, still the old boys club. Now in Cook County, that has started to change. From even the chief judge, Tim Evans, who is the chief judge over the whole system, there's been a lot of minorities who have been elevated to the bench. Many of my friends, I was offered an opportunity to become a judge. I said, no, I don't want to be a judge. I want to retire and get involved in ministry. And it was a good job, they said, but I said, nope, I'm ready to go. So anyway, the point of the matter is that there is still some disparity in terms of the whole scenario here. So we have to look at and see who's in prison, who's working in law enforcement, who's on the bench, and apply those to what is happening. And let's look at some reality. Regarding this thing here, the video will give you details of the investigator. There's some problems with this. I don't know what's happening. Someone's brought it to my attention. I thank them. I've passed this on to the personal support system. I have them created a ticket to look into this and see what they need to do to fix this link. So as you find links that don't work, please let me know, and I will work on getting them. I tried some, but I didn't see this, and yeah, it does lead you to something that you don't want to have to go to. Now, briefing a case, and this gives the how to brief a case: facts, procedure, issues, holding, reasoning, concurring, and dissenting opinions. Now, some people don't think dissenting and concurring opinions are important, but they are important, not just even in some way, as it says, because concurring decisions means that the court, the person who wrote that opinion, didn't agree with the majority, but they agree with some of the stuff. And when they say is that, but they decided not to go along with the majority for whatever reason. Dissenting means they totally disagree, and they'll provide their reasons for it. Dissenting cases change. Let me give you one really good example. There's a United States Supreme Court that you'll study in history called Plessy, Plessy versus Ferguson. I think it's Ferguson. It was a case that said separate but equal was the law of the land. And in the law, it allowed separate but equal to exist, and it was a United States Supreme Court decision. However, Plessy versus Ferguson was overturned in 1954 by the now famous Brown versus the Board of Education decision, which said that separate but equal was not good, and it was not good for the people as well. Brown versus Board of Education, yeah, May 17th, 1954, 52 to 54, but 1954, 347 U.S. 483, and so it applied to public schools, but it also applied to a lot of other things. So the bottom line is that I'm able to be in classes with individuals of different races because of that case. And so what I'm going to say to you is that if you ever read the dissent of Plessy versus Ferguson, you could see that there was some idea that this separate but equal thing wasn't going to be so good. And then the Supreme Court finally successfully, with the lead attorney, Justice Thurgood Marshall, who later became Justice Thurgood Marshall, argued the case as a lawyer for the NAACP Legal Defense Fund. And it just changed things and allowed individuals, and it said things like, you know, the facilities the playing field need to be balanced. So anyway, so that's why I said dissenting opinions can be future. Okay, so regarding the course project, bear with me here. It says that your due dates, and you already know what they are, for week 2, introduction and a topic selection. Week 3 and week 4, week 5 and 6, and it tells you what you have to do in each of these assignments. And then it tells you what your requirements are. For your project, you must choose an aspect of the 4th Amendment. This is the 4th Amendment, people, not the 5th, not the 6th, not the 2nd Amendment. Thank God. The 2nd Amendment is about gun control, and that's a whole nother discussion. But research the case law surrounding it. Discuss a relevant recent case or event. There's plenty. Ooh, buddy. Offer your opinion of the law and its current side and changes you might make and why. You can talk to judges, state's attorneys, police officers, prosecutors, public defenders in your area, and interview them, learning about the 4th Amendment and so forth and so on. It's going to be a very valuable thing. Then your final paper will be 6 to 8 pages long, not including the cover page and the reference page. And you should follow APA guidelines and so forth and so on. Each of the assignments are evaluated separately, as I said. So that's what you got to do. So you already know the assignment for week number 2. Again, I went over a little bit because I wanted to make sure I covered in detail this issue so you understand equal protection, and then briefing a case. And then I wanted to definitely make sure that you were good and up to speed on the course project. Again, before I adjourn, I want to take you back to the assignment again. Come on. Come on, come on, come on, come on, come on, come on. Slow computer. Okay. I want to take you back to the assignment for week 2. So look up the 4th Amendment and, you know, write a 1-page paper. So it's not very much involved there about your topic selection. So you're setting the pace. And there's a zillion things under 4th Amendment that you're going to be able to deal with. And so with that, any questions? If so, type in the chat box. And if I don't see any, it says not extended. Does that mean that they are not covered by this? Baston versus Kentucky has not been extended. No. Here's the deal. Here's the deal. When it says it's not extended to something, what it means is that there hasn't come up a case that will create that situation. That's a good question. And so when a case comes up before the Supreme Court that will do that, and I wish that you would put that publicly, because I'm going to read it. It says it's not been extended. Doesn't that mean that they are not covered by this? No. What that means is that it still hasn't been decided. So that doesn't mean they're not covered. The way that you know if someone has been covered is if it actually goes to a case. So let me go back. I want to go back to sharing my screen, since you said that, and I want to take you to something. And if you read the case, you'll see why I said what I said. Okay, now let's go back. Oh, it's not here. It's in the lesson portion. Okay, let's go back. Yeah, I think I know what you're saying, but that's why I said what I said. Okay, it says has not been extended universally. No, when it says universally, you know what that means? It hasn't reached the Supreme Court yet. But it has been challenged in the state courts or in the lower courts. But it hasn't been, there hasn't been a case that had gone up to the United States Supreme Court. But trust me, in our age that we're in now, with age discrimination, with gender, and the LGBT and the civil rights stuff, you got to remember now. And then some of this material that's written here needs to be fixed because of the civil rights laws that have changed regarding LGBT and gender and marriage and all that kind of stuff, and or religion. And so it's determined. So I'm telling you this, that is why I said what I said about it's being extended to these things, but not when it says universally. You have that one word makes the difference in it. So does that clarify it for you? Oh, okay. All right. Yeah. Yeah. A lot of people say, yeah, yeah, you're right. But the way that law changes, and that's how the Brown versus Board of Education came about, it went to the Supreme Court. Hey, guys, remember this case. And some of you may be familiar with, because there was a movie that was done about it. Virginia versus Loving versus Virginia. Anybody ever heard of that case? No, we're going lower, but you ever heard of that case, Loving versus Virginia? Any of you? It was a 1967 United States Supreme Court case that ended up going all the way to the United States Supreme Court. And here's what that was. They did a movie called Loving, L-O-V-I-N-G, and you can Google it. And it's available now on DVD, and probably it's on YouTube and so forth. But anyway, in that case, it was decided for the first time, people, universally, even though in some states where it happened, that integrated marriages were legal. In the state of Virginia, they were not legal until the Supreme Court stepped in. So there was a Caucasian man who married a black female, and they became criminals in Virginia because they violated the law. And the law was challenged and went all the way to the United States Supreme Court. And the United States Supreme Court, in the famous case, Loving versus Virginia, 1967, it was, let's see, I talked about this in one of my other classes. Loving, oh, here it is. Loving versus Virginia, 388 U.S. decided in 1967, where it was unanimous decision, people. So that's what I'm trying to say to you, is that that's what that means there. So even though it was legal in some jurisdictions, like Illinois, we didn't have that problem. In 67, it was happening in Minnesota, Wisconsin, other jurisdictions, but not in Virginia. Okay, it was patently illegal. And so the Supreme Court said, no, we're not going to stand for that. That is a fundamental right that individuals have, a right to not determine someone can't love somebody of another race. And that's the kind of way that the law changes in those kind of situations. Someone has to challenge it. So I wanted to share with you that. So anyway, 9:45, 15 over. This course really excites me, and I think you'll learn a whole lot here. Equal protection. That's what I want. You give me that. That's all I want you to give me. Well, I want you to listen to the whole video, but equal protection. And so with that, I'm going to say good night. Thank you guys for being patient. But I think you learned quite a bit. I didn't just use the information. I gave you some experience and my expertise in sharing to help illuminate what you're going to discover from your research and reading. So with that, I'm going to say good night to each of you, and I'm going to end this session. See you next Monday at the same time, 8:30 p.m. Central Standard Time. Good night.